Hi everybody, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney and I'm coming to you from my office in Brooklyn, New York. Now, I wanted to do a video and explain settlements and the way we prepare for trial, and while we want to settle a case, how it usually plays out in real life. And I wanted to give you two examples of cases that I'm actually working on right now, and they're both traumatic brain injury cases. One is a trial that I was supposed to start today, and it got shortly adjourned. It's going to actually start in beginning of June, so just a few days. But we had an offer of about $120, $130, I think it was, $1,000 on this case for the longest time. And one of the other lawyers in my firm actually wanted to take the offer, and I said no, because it's a potential traumatic brain injury. Let's work up the head injury. Let's send the client to a neuroradiologist, to a neuropsychologist, to a neurologist. And when we did that, they actually did find evidence of traumatic brain injury. For example, in the diffusion tensor imaging scan, I believe it was like 13 out of the 30, almost half of the white matter tracts were damaged, were severely, it's called anistrophy, right? They found that, fractional anistrophy. So they found damage. That's just one example. And there's a lot of other examples. Plus the client has PTSD. So I sent them a letter and I said, pay me $4,750,000 by May 9th, because they had a $6 million policy, 1 million with a 5 million excess. So I figured, like, okay, I'm allowing you to save a little off your policy. It's a serious injury. Pay me the 4.75. And they didn't respond. And then after the deadline had already expired, and by the way, I want to add a caveat that in the letter it says once the deadline expires, the minimum will then increase, the value, the minimum we will accept will increase from the 4.75 million to 7 million, right? It's right in the letter. It's like a long letter, like a 20-page letter. So it's right in the letter. It's going to go. So they let it expire, so it's already 7.5. And at that point, they send me a text or an email saying, oh, we're going to increase the offer from $120,000 to $250,000. So I'm like, look, thank you for increasing. It's good that you're moving in the right direction, but you're still 7.25 million short, right? And as soon as I go into court and I start picking that jury, it's probably going to go up to 10. So this is just the way I negotiate. This is just the way I do it, right? I see the case, I see what it's worth, and I just go for it. So I'm not going to like beg. I'm not going to play their game, because what they're trying to get me to do is come down, right? And then I could probably settle the case for $1 million, but I have to come all the way down into their realm, right? Into what they want to settle, into their ballpark. And I don't want to do that because I really think it's worth a lot more. I think I have the case. I have the liability. I have the damages. So why should I? You know, so you just have to be a little fearless, and that's how you get them to pay. Now, the other case, we also went, and they're both in the same courthouse, by the way, which is the Bronx. The other case, we went to a settlement conference, and it was with the judge. And also, it's actually a young individual. He was in his 20s when it happened, so he's got a lot of future pain and suffering and a lot of lost wages. And I believe in that letter, I said I was asking for 13 million because the lost wages in that case were so high that they were like 7 million just in wages, and then another 6 million to past. And the past is actually a span of almost 10 years now. So it's not that much, 2 million for 10 years of suffering with a brain injury. And then in the future, you're talking about 50 plus years, and it was, 4, right? Because the total is 6 for pain and suffering and 7 for the lost wages, 13 total. That's what I put in the letter. But we would actually, be negotiable, but they come up and they say at the settlement conference, oh, all we have right now is $300,000, right? The first case was 250. This is 300. So they're doing a little better than the first case. But you see what I'm saying? They're just completely and ridiculously unfair. And then they also say, well, if you would take it, if you tell me you'll take it, I can make a call and maybe get you $1 million. Like $1 million is all the money in the world. But it's absurd because these cases are worth a lot more. And their argument was, well, look, we don't even believe that there's a brain injury because the CAT scan taken after the incident did not show blood on the brain. But like, if you actually know anything about traumatic brain injury, the CAT scan doesn't show the axons, right? You have 84 million neurons, and then you have axons, and that's how like each neuron talks to it talks to others is through these axons, and the axons could get sheared, the axons could get cut or torn, and you're talking about 84 billion neurons, and the whole brain is a jelly, so it sloshes, and it's very, very vulnerable, and it's microscopic. It's to get into that level, it's very microscopic. No CAT scan is ever going to show that. And you don't need to have blood on the brain. Blood on the brain is a very serious injury. That's actually a subdural hematoma or a subdural hemorrhage. I've had cases like that as well. But you don't have to have that. It's like saying, oh, I don't believe that you had a herniated disc, and I don't believe that you needed diffusion because look, the X-ray doesn't show any injury, right? Because X-rays don't show discs. It's just impossible. X-rays only show bone. If you don't have a broken bone, it's not going to be on an X-ray. So you can have so many different types of brain injuries, and it will never be on a CAT scan. And so just the point that they were even saying this is like from the 1930s or 1950s. It's just mind-boggling to me. So I kind of spoke up and told the judge, but the judge didn't really seem to know traumatic brain injury either. So we're going to have to do it through the court. But so it's just an idea. So it's a little frustrating because I know people want to know, how much is my case worth? How much am I going to get? When am I going to get it? But sometimes, even when you have, and I think both of these cases are very strong cases, sometimes even when you have a good case and you've prepared it correctly and you're ready to go, the other side is just not fair. And there's not really any way to make them be fair other than to take them to a jury trial and let a jury decide. So that's what we're going to do in both of these cases. So I hope this was helpful. Let us know what questions you have. We are here for you. Our goal is helping serious injury victims and families. And I'm getting ready for these trials. I don't know if you could see, but I've got a bunch of notes, deposition transcripts. I got my whole papers here. I also have binders, trial binders. I'm ready to go. I'm making exhibits, medical timelines. I'm getting ready on this case for the beginning of June. And then the other case that I mentioned, the second case I talked about today, that one's going to go probably in September. So 2 traumatic brain injury cases. Okay, everyone, have a great day, and we are here for you. Please like and subscribe to our channel, and we're going to do another Raw Law where I go live later this week, probably like Wednesday and Thursday this week, because Monday and Tuesday I have to get ready for these cases, but I think probably towards the end of the week we'll do that. Okay, everyone, have a great day. Bye-bye.